Welcome to my channel, Keeping You Obeying Us. My name is Travis Creighton, the estate of my mom, Geraldine Ann Creighton. I go by the online moniker of Florida's Unrelenting Citizen. This is my father, Terrence Creighton, my mom, Geraldine Ann Creighton. They unfortunately both suffered from medical malpractice in Florida. If you look at the medical record here, the very top entry is a medical transfer that took multiple days to occur. However, this is inaccurate. This is a falsification of the medical record. Below it is a heparin order that was rejected by the pharmacy because it was overdosed, causing over a 3-hour delay in this medication alone. You'll notice that it's a two-step order. Step 1 is the bolus, and step 2 is a drip. In reality, the drip was done before the bolus by 45 minutes. During this time, my mom experienced chest pains. This was documented in the adverse medical incident that was not disclosed to us. You'll also see right here, the center arrow, that the hospital also did not disclose it to the physician. If you read the description, underlined is an unidentified nurse. There's a field with this other arrow that says other persons involved, specifically so you can identify unidentified people. If you look at the regulations for filling out an adverse medical incident, subsection D and E, these were violated. D says a listing of persons then known to be involved directly in the incident. That would be the nurse in RIO. Also, a signature on the form is absent. This is not a legal or valid adverse medical incident that was filed internally. It was not reported to ACA. If you look at the metadata on this, you'll see that it was created in December of 2020, months after the adverse medical incident occurred. You will also see that it's modified, so this is not even the original document. If we look at the heparin orders that were supposed to be given to my mom hourly, you'll notice that the nurse performed all these in the same 2-minute time span of 16:38 to 16:39. She charted it at this time also. She never walked into the room, never did her hourly rounds, never confirmed that the machine was infusing the medication properly or at all. However, she got paid by Medicare, and I would say that this qualifies as a False Claim Act violation. That wasn't the only order. Here's another one. Exact same time frame, 1640. When she performed it, also when she charted it. Again, she never did this work, but she got paid. My mom never received this medical care because she never checked in on her. Now let's look at the transfer. The top is the transfer I spoke of earlier. The bottom is the second one. Let's look at the time and dates. The top one was issued on the 19th. It says it was completed on the 21st. So who wants to go to the emergency room and wait 2 days to get transferred to a progressive care unit? But now let's look at the bottom one. It's also to the exact same progressive care unit. So if you're in the progressive care unit on the 21st, why on the 22nd would there be a transfer order to go to the very unit that you're in? It's because the first one never occurred. It's falsified. Please note that it says medical necessity for both of them. There should not have been a delay. Now, I'll prove the point using medical care by a nurse. This nurse right here, Nicole Hatcher, she was the one providing care, and it could have been any other nurse that I chose. But this just shows that on the 20th, she was providing care to my mom. Now let's go to post-transfer care. On the 22nd, at 18:01, that's 6:01 p.m., on the 22nd, Nurse Hatcher was still providing medical care. However, the transfer says it occurred on the 21st. So how is the nurse providing medical care on the 22nd when my mom is supposed to be in a different department and nurses do not transfer with the patient? But I'll prove it again using billing records. On the first 3 days, the 19th, 20th, and 21st, you see a charge of $1251.97. My mom was in the same unit. Then on the 22nd, you see an increase of 3583.18 because my mom was transferred to the PCU. But why is there a charge for 1251 on the 21st if my mom was transferred to the PCU? Billing records prove my mom was not transferred. Billing records prove the medical record was falsified. The hospital did not bill Medicare because they didn't want to violate federal law with a False Claim Act violation. Here's the document side by side just for you to take a quick look at all the information. Now let's talk about receiving medical records. Under HIPAA, you're entitled to all your medical records. Actually, it's the designated record set, which includes billing and other information. On October 7th, 2019, this is the first release of medical records that the hospital gave me. I said records are missing, and they ended up giving me this attestation letter dated December of 2019, where they say there is no further documents to provide you. Everything that we have in our records, you have received. That is unambiguous. Everything that they have, I have. However, I still found records that were missing. So I filed a complaint with HHS OCR, Office of Civil Rights. And on June 1st, 2021, the parent company, Advent Health, their corporate responsibility officer again attested to a federal agent that all medical records were provided to me. Still, I knew records were missing. So I went in person to the hospital on the 13th of December, asked for new records. I showed them why records were missing, and they gave me a CD on the 14th. There was nothing new on the CD, nothing new in any printed records. But they did tell me to go online, file not a complaint, but a records request through their website, and it would go to a third-party servicer. So I did that. And on 12/18/2023, I received new records. This is the cover sheet for what I received. This is one example. You can see the date, 12/18, at the very bottom under this arrow. And you can see that there's at least 89 pages. There's really about 100 of new records. If you look at this top inset where I kind of zoomed in here, it says auto release of 9/25/2021. Now, an auto release is an automatic date. It's a date that automatically releases medical records designated to be released on this date. This date is 2 years and 2 days after the statute of limitations in Florida runs. The 2 days pushes it to a Saturday. Pretty devious. These icons here do not show anywhere else in the previous medical records. I can search for these numbers. I can search for a lot of information on this, of the records that I previously received, and none of this information is found. It's proof that these are brand new records, never seen before. So they were withheld for over 4 years from the estate. How am I supposed to perform a pre-suit investigation without having all the medical records? Now let's look at the list of disclosures. Let me zoom in here and highlight some stuff. Look at these dates on the left side. These are the dates that subpoenas for records were answered by the hospital. Now compare it to the auto release date of 9/25/2021. The subpoenas were all fulfilled before this auto release date expired. So my question is, are all my complaints that the government agencies investigated, are they done without the full medical record? Are they null and void? Or did the hospital give all the records to these agencies, but purposefully withheld these records from the estate? Either way, it's not right. Laws have been in violation, state and federal. Now, here's an example of medical malpractice, I say. Patient became apneic shortly prior to extubation. Why would you extubate a patient just out of surgery if they just became apneic? Apneic being they stop breathing. You have an active airway. Why would you extubate them? You have a SAT and SBT, spontaneous awakening test or trial, and spontaneous breathing trial. This right here would have failed both of those. There is no medical reason to extubate. Capnography monitoring says it right there that I should have those records, but I do not. They're being concealed. This transesophageal echo, also known as a T, this was performed during the CABG surgery. I have no record of this whatsoever. It's being withheld. They performed another T during my mom's code event. These are the still images from them. And these boxes, those represent missing records. I do not have these, and you see that I put them in sequential order based on time stamping of the metadata. I would say that they are purposefully withholding records to prevent medical malpractice from being proven. I can't perform a proper pre-suit investigation. One, because of statute. Get this. Florida Statute 766.202 subsection 5 defines an investigation for the purposes of a pre-suit investigation as an attorney consulting an expert, a medical expert. Because 768.21 subsection 8 denies non-economic damages, I cannot get an attorney to perform the pre-suit investigation per the statute. That means I can only go to court on statutory violations, which is what I tried to do. That's a whole nother video. Now, with my HHSOCR complaint, there was an investigation, and I FOIA'd the results of that investigation, and I found this document. This is the cardiac surgery weaning protocol, the SAT and SBT protocol for extubation. This document does not exist in my mom's records. However, it's a HIPAA record. HIPAA defines a record as having patient identifiable information and medical care information. Both of these insets that I have identify this as a medical record. But if you look at the green here, it says, do not scan into chart. Clearly a federal HIPAA violation. No reason for that to exist. My mom and dad both died in Florida of medical malpractice. I'm sure of it. That's my belief. My dad, I know, it was admitted. My mom, I'm fighting to show it. I think the records show it, but I can't get a medical expert to say it because I have no attorney. Florida Statute 768.21 subsection 8 allows this abuse, a medical record denial, fraud to occur because HIPAA doesn't allow a private right of action and Florida law doesn't allow it either for a lot of the statutes. Without an attorney, we're nothing but lambs to the slaughter. Now, consider this. ACCA regulates hospitals, but if ACCA only charges $100 or $1,000 fine, $1,000 fine for a violation, it is financially beneficial to pay the $1,000 fine due to lack of documentation than it is to have the documentation and take on the liability that that documentation could expose you to. This law needs to go, and Florida healthcare needs to be held accountable. Thank you.